The history and source of contract law in the United States. A contract is an agreement that's legally enforceable. Not all agreements are enforceable in court. These are not contracts. A contract carries the power of the judicial system. If one party fails to deliver on his promise, he can be forced to deliver or forced to compensate by the court. The courts have long been prepared to enforce contractual agreements. The economy is driven by trade, trade is based on agreements, so contracts are essential to the operation of the economic system. The basic elements of contract law arrived in the United States with the first settlers from England, where the law had been decided and developed by judges deciding cases. The right to contract is considered important to the success of the nation, and the US Constitution contains a provision that prevents the states from impairing contractual obligations. The law of contracts is essentially state law. The states can define their own rules, but they are restricted by the Constitution from impairing the ability of their citizens from entering into binding contractual relationships. As time goes by, more and more cases are decided, and keeping track of the common law becomes an increasing challenge. The Restatement of Contracts is a synopsis of the current state of common law. Sponsored and officially promulgated by the American Law Institute, restatements are attempts by prominent attorneys and scholars to distill from the body of decided cases the general principles of law in a given area, and state them in a concise way, together with explanatory commentary and illustrations of how they are applied. The common law of contracts has recently been displaced by Article 2 of the Uniform Commercial Code, which deals with the sale of goods, and which we will talk about in more detail on a subsequent slide. The sale of goods, i.e. things that are movable, is generally covered by state statutes derived in whole or in part from the Uniform Commercial Code, the UCC. Other contracts are generally governed by state law derived from common law. The UCC is one of a number of uniform acts that have been promulgated in conjunction with efforts to harmonize the law of sales and other commercial transactions in all 50 states. This objective is deemed important because of the growth of commercial transactions that extend beyond one state. For example, where the goods are manufactured in State A, warehoused in State B, and sold in State C and delivered to State D. The UCC deals primarily with transactions involving personal property. That's movable property, not real property, immovable property. The UCC, as the product of private organizations, is not itself the law, but only recommendations of the law that should be adopted in the states. Once enacted in a state by the state's legislature, it becomes true law and is codified into the state's code of statutes. When the code is adopted by a state, it may be adopted verbatim as written, or may be adopted with specific changes deemed necessary by the state legislature. Unless such changes are minor, they can affect the purpose of the code in promoting uniformity of law among the various states. The UCC, in one or another of its several revisions, has been enacted in all of the 50 states. Louisiana has enacted most provisions of the UCC, with the exception of Article 2, preferring to maintain its own civil law tradition for governing the sale of goods. So Louisiana's laws in this area of sale of goods are somewhat out of harmonization with the other 49 states. The United Nations Convention on Contracts for the International Sale of Goods has provisions similar to the UCC and has been ratified by the US and adopted in many countries. In the US, where the UCC is silent, the common law of the state controls. So, the common law is often referred to when deciding contracts for services, and contracts that do not involve the sale of goods. When a hybrid contract involves both goods and services, the court usually looks at the predominant purpose of the contract. Was the predominant purpose of the whole agreement a transaction in goods or in services? If the predominant purpose of the contract is goods, then the court looks to the UCC for the rules to apply. The doctrine of equity is sometimes applied in contract cases. Law courts focus on money damages. Equity courts have broad scope to do justice, beyond money damages. The slide shows on civil procedure and remedies explain the distinction in more detail. One significant difference is that there is no right to jury when the judge sits in equity. Equity and law courts merged in the United States some years ago, and the same judge can now administer remedies in law and equity in the same case in the same court.